and welcome to the Week 9 video lecture. We're going to be talking about hearsay. Hearsay is one of those rules that are really very important to evidence, as you might imagine. The reason why it's so important is that hearsay, at least in the classic sense of hearsay, is really not sufficiently reliable enough evidence for us to use in a court. For instance, if someone comes in and says, well, I heard someone say that they heard someone say that they saw the accident, and it was the plaintiff who was wrong, not the defendant, that kind of hearsay may actually have occurred, and maybe even somebody may have said that at one time, but we have no way to examine whether they actually saw it. We have no way to examine whether they're telling the truth. We don't know who they are. And even if we did know who they were, we wouldn't have any idea whether what they were saying was reliable or not. People are not under oath. They're not aware that they have to tell the truth. Someone could just be making something up. And certainly we could make up a statement like that from somebody and bring it into court. So it is just completely inadmissible because it's just not reliable enough evidence to base anything upon in the classic sense. Now, what I want you to know about the hearsay rule that we're going to get into this week is that although the hearsay rule does prohibit hearsay evidence from coming into court, that exclusionary rule has almost been eaten up by the exceptions to the rule. There are so many exceptions to the hearsay rule that other than the classic hearsay where it's the person saying that they heard someone say, and not even know who it is, that something happened, that kind of very classic hearsay, probably we're going to be able to get that hearsay into court. There are a tremendous number of exceptions that we'll go over every one of those, at least the ones that you will need to know for purposes of being a paralegal. So let's go over what we're going to do specifically on Chapter 9 on hearsay. First, we're going to introduce you to the rule and talk to you about the purpose of the rule. And then we will introduce what's called non-hearsay. Those are statements that are being brought into court, but they're not being brought on, as you'll see, for the truth of the matter asserted, and so they're not actually hearsay. And there's actually some rules, at least in the federal world where it is truthfully hearsay, but the rules just define it away as something other than hearsay, even if it's actually hearsay. We'll see how that pans out in a few minutes. Then we're going to talk about nonverbal assertions. We're talking about things such as body language. A swipe under the neck with a finger is typically a nonverbal assertion. It means I'm going to kill you. And that would be something that can be a verbal assertion. So it's possible that it could be part of the hearsay rule, depending upon what it is. So in essence, it doesn't have to be words spoken to necessarily be subject to the rule. We're also going to look at evidence that is not hearsay because the rule says it is not hearsay, even though it actually is. It's defined as hearsay, but under the federal rules, not the state rules, but the federal rules, they just define it away as something other than hearsay. It's just one of those odd categories. We'll get into that. Evidence that is not hearsay because the court says it is not. That's what we're going to get into. All right, so let's get right into some of the other aspects we're going to get into for tonight. Identifying non-hearsay uses of evidence offered for purposes other than to prove the truth and understanding the limitations. So we're going to get into times when we're going to bring in statements that have been made outside of court. We're going to tell the judge we're going to bring it in for a purpose other than to prove the truth of the matters that are asserted in the statements. And then we're going to see that that these can still sometimes be prejudicial to the other side because juries still take those things as if they're gospel, unfortunately. And because of that, courts will actually admonish the jury that they may not use it to prove the truth of the matter asserted, may only be used for a particular purpose and only that purpose. A good example of that, for instance, is I used to put my officers on the stand and I'd ask them, did you get a call to go to a certain location at about 3:07 p.m. on such and such day? And they'll say yes. And what did the call say? And then I pull an objection, hearsay. It's an out-of-court statement brought on to prove the truth of the matter asserted. And I would say to the judge, well, Judge, I'm not really bringing it on to prove the truth of what was said in the call. I'm just bringing it on to explain why the officer went where he went that day. And the judge would say, okay, well, then I'm going to tell the jury, listen, you're going to hear this something about a call to the officer probably from his dispatch, and you're not going to be allowed to use that call as indicating any truth about what was said in the call. You can only use it to explain why the officer did, and if anything, in response to the call. And then that will get it so that we have a at least the jury understanding that just because they got a call from the station about that something was happening does not mean that it was happening. At least they can't use it for that purpose. They have to use it for some other purpose, like telling them why the officer went where he went at that particular time. We're going to look at verbal acts. These are things that are not specifically hearsay. We'll see what those are in a minute. And then implied assertions. We'll look at those as well as another category of things to look at that might or might not apply to the hearsay rule. Okay, let's get right into the hearsay rule. This is it from FRE 801 and California 1200. They're exactly the same, as you might imagine. As I told you, federal rules were the model for many states, and California is one of them. Although California does have some differences, as we've seen. Hearsay is, quote, a statement other than one made by the declarant while testifying at the trial or hearing, offered in evidence to prove the truth of the matter asserted. A good example of hearsay would be we have a witness at the scene of an accident. They did not actually see the accident. They heard the noise of the crash, but they also heard someone who said, "Oh, did you see that driver in the blue Pontiac? He ran the stop sign, and that's what caused the accident." Now, it may be that we don't even know who that person is because they were never identified. And we want to bring that statement in because it's obviously someone who witnessed this thing and actually saw what happened and can tell us who would be the one who committed the accident. But it's hearsay. It's a statement, and it's one made not by the declarant while testifying. So it's a statement made by a declarant not while testifying, and it's offered in evidence to prove the truth of the matter asserted, meaning that the person in the blue Pontiac was the one who was responsible for the accident. That's classic hearsay. We'll see later on that one might get in under an exception, but it is absolutely 100% hearsay. That's the classic scenario, is that someone we don't even know or can't identify or they're not available to come in and testify is saying something outside of court and is being brought in to prove exactly what they were saying. And it's really very, very potentially, not potentially, it is unreliable generally speaking, and only in cases where we found that it is sufficiently reliable will we allow it in. And where we have found it to be sufficiently reliable, we've made an exception to the hearsay rule that cuts out that section and allows that in. Okay, so there's two elements to this. There's an out-of-court statement. So it has to be, if it's a statement made by the declarant while they're actually testifying, it is not hearsay no matter what. By the way, it could be a statement by the declarant who's now testifying as to what they said outside of court. And if you're asking him, didn't you say something different outside of court? Now you're talking about a statement that they made outside of court, and now it does apply, even though it's the same declarant who made the statement and is also testifying. So remember, it just has to be an out-of-court statement. It doesn't make a difference who made the statement. It could be the person who's actually testifying or any other person, even an unidentified person. But it just has to be a statement made outside of court. All right, number two is it's offered for the truth of the matter asserted in the statement. So you're offering the statement to prove the truth of what the statement says. If you're doing that, you have those two elements, you have hearsay. Under both federal and state rules, that's the classic version of what is hearsay. And we'll see that the feds, unfortunately, have defined away certain hearsay as something other than hearsay, and we'll get into that here in a few minutes. But for the most part, if you see those two elements, you're going to get a finding that it is hearsay. What the next question is if it's hearsay, then are there any exceptions that allow it in? Is sort of the next question. All right, so let's get into the general rule. General rule is that hearsay is inadmissible unless a specified exception applies to allow it into evidence. The purpose behind this is to limit the admission of inaccurate, actually not inaccurate, it might actually be accurate testimony, but it will be unreliable. That means it's impossible to really rely on it when you can't see the person on the stand who actually saw the thing, and make sure that they actually saw what they say they saw, and that they are trustworthy because they look like they're telling the truth, and they have no, maybe they have no biases or prejudice, and they're just a witness, and maybe it would be good stuff. But if it's outside of court and that person's not in there to be examined by either side, then we have no idea whether what was being said was truthful or not. Remember, the person's not under oath. It could have been taken out of context as to what they said. It could be they never actually saw anything. They could be repeating what somebody else said, and now we have double and triple and quadruple hearsay, and we have no idea where the statement originally came from, let alone whether it was ever reliable. All right, so hearsay is unreliable because it's not under oath. The jury cannot determine the credibility of the person making the statement, and the statement is not subject to cross-examination to determine whether it's the truth. These are the filtering processes that we have to test the reliability of any testimony that comes into court. Without it, then we don't have a reliable testimony as far as we're concerned. Okay, so let's first define what a statement is for the hearsay rule, because this is important. When we use the word statement, we're using it in a very broad sense. We're not using it in the normal sense of it is a series of words coming out of somebody's mouth. It's defined as an oral or written assertion, or nonverbal conduct of a person if it is intended by the person to communicate. It's intended as communication. Some message is trying to be transmitted from the person, either in oral, written, or nonverbal conduct form. If it is that, then it is a statement. So your slash under the neck with a finger is nonverbal conduct. It is intended to communicate. It says, I'm going to kill you, or you're dead, essentially is what it's saying. Okay, let's look at nonverbal communication. It also includes a nod of a head, a finger swipe under the neck, thumb and forefinger making an O, which means okay. Pointing with the finger in a particular direction means go that direction, or whatever's going on is over there. Other kinds of body language as well can all be considered statements. These are very important to note because they are statements that are subject to the hearsay rule if that statement is being brought in for the truth of the matter asserted. Okay. All right. Let's look at verbal acts. Now, any verbal statements made along with conduct to create legal relationships or to define the context of a transaction are not hearsay, such as contract terms, for instance. So, for instance, we might actually have a contract. It might be in writing, and we might bring in the actual contract into evidence and say, Judge, I want to introduce this contract because I will authenticate it as the deal that was made between the parties and has signatures on it and so on. And you're going to immediately pull an objection. Hearsay, Judge, it's an out-of-court statement brought in to prove the truth of the matter asserted. Well, it's an out-of-court statement because there's lots of statements in the contract, lots of written statements as to what the parties have agreed to. And by signing it, it really becomes the statement of each party that signed it. But it's not being brought on for the truth of the matter asserted. It is actually, it's simply the actual terms. It's only being brought on to actually establish the terms of the contract. And it's not being brought on to prove any truthfulness of those statements or agreements in the contract. It's simply being brought on to prove that those are the terms of the contract. So that's a little bit of a distinction that's kind of hard to grasp, but all you need to know is if you've got a document out there that creates legal relationships, such as a will, such as a contract, such as a check or a note or any kind of writing where people are somehow involved in some sort of transaction of any kind, then the actual terms of that document are not going to be considered a statement for purposes of hearsay. It's not considered a statement for purposes of hearsay. So if the words accompanying physical conduct and serve to shed light on the physical contact, they are most probably verbal contact and not hearsay, such as saying ouch after an accident. We're not trying to bring in the statement ouch for the truth of the matter asserted. It's actually just an expression of what's going on. It's a more or less circumstantial evidence that the person was feeling pain. And that's why we bring it on. We're bringing it on as circumstantial evidence of the pain. And in a sense, verbal acts for contracts, we're bringing on the contract terms as circumstantial evidence of what the agreement was between the parties. So essentially, if we're using the statement as circumstantial evidence to prove something, we're going to find out that it's not going to be a statement for purposes of the hearsay rule. And that happens in a lot of them. I'll give you another example. Let's assume we have a briefcase that has the initials JNL, which happen to be my initials. Let's assume we have that going on. And we want to bring that briefcase into court, or a photograph at least of the nameplate on the briefcase, so we can show the jury, because maybe we found something that shouldn't have been in the briefcase, and that person's being prosecuted for having whatever those things are. And they want to prove ownership by the fact that that those initials are there. Well, are the initials a statement? Well, actually they would be, because it's intended to communicate. It's actually someone writing their initials down to communicate to everyone that this is their property and nobody else's. So it may be a statement for that reason. But what's really happening is we're using the words, or excuse me, we're using the letters J and L together with an inference that people write down their initials on their property as a way of indicating ownership, and therefore that this briefcase is owned by JNL. Well, okay. Then what's happening is we're using this statement, so to speak, as circumstantial evidence of another fact based on using an inference or some other fact or circumstance that we use to put the two together, and then we say that must be his briefcase. So we'll get into more of this. We'll get more practice on this just to give you a better clue on this. But it's very important for you to see that if there's anything that involves any kind of creation of a legal relationship, where we're bringing in the terms of that legal relationship, or words of physical conduct where it's somebody doing something around some sort of physical conduct, and they're saying something, usually an ouch or a man that hurts, that kind of statement. We're really doing it as to show circumstantial evidence of something else. So we're not bringing the, ouch doesn't really have any meaning, if you want to look at it that way. Ouch, if we're trying to put on the word ouch, it has no meaning by itself. It only has meaning if we add to it the fact that people say ouch when they get hurt. That's why it has meaning. So essentially, it's not being brought on for the truth of the matter asserted. It's actually just circumstantial evidence of what it is we're trying to prove. And if that's the case, it's never hearsay, ever. All right, two main considerations when assessing verbal acts. If the words create a legal relationship between the parties, they will be considered verbal acts. If the words accompany physical conduct and serve to shed light on the physical conduct itself, they are likely to be considered verbal acts. So physical conduct means you're doing something. You're demonstrating something. It could be that you're hurt. It could be that you were sleepy, that you were tired, and there could be words or statements or body language. Someone walks half hunched over, their arms dangling down as they're walking. That's actually could be considered a statement in a sense, because you're trying to communicate to people you're very tired. Or if someone asks you to do something and you start walking that way, it's a very good body language for saying, I'm very tired, I don't want to do it. And so we consider that a statement. And so we might think of that statement as being possibly subject to the hearsay rule, but it's not. And the reason why is because it just happens to be really circumstantial evidence to prove that the person was in fact tired, is they were indicating they were tired through some physical conduct. All right, let's look at the other element, which is offered to prove the truth of the matter asserted. That's the second element of hearsay. Remember that you always go back. If you want to know whether something's hearsay or not, you ask two questions. Is it a statement? Number two, is it offered to prove the truth of the matter asserted? Excuse me. The first rule is it an out-of-court statement? Second rule is it offered to prove the truth of the matter asserted? If so, then you have hearsay. Okay? All right, so let's look at the second element, offered to prove the truth of the matter asserted. If the statement in question is not offered to prove the truth of the matter asserted in the statement itself, then the hearsay rule never applies, ever. And that's the luggage example I gave you, where the JNL is inscribed on the luggage. And this is a statement offered to prove that the luggage is owned by Jerry Legian, but the problem is that it's not really, J&L doesn't prove anything by itself. It's just yes, it is a statement, but in order for it to be used as proof, it has to be added with the custom of people putting their initials on things as a way of indicating ownership, and therefore circumstantially then it must be mine kind of logic. So it's really circumstantial evidence rather than in essence, whatever is in the statement has to by itself prove something, or it's not capable of being put on for the truth of the matter asserted. I hope you see it that way. If you cannot prove something with the statement itself, then you're not. Let me give you an example of that. You have someone who saw an accident. We never found out who this person was, but we heard them talking right after the accident, and they said, yeah, the blue Pontiac was the one that, gosh, did you see that? The blue Pontiac, he's the one that ran the red light, and that caused that accident. Well, that statement would be testimony because it's showing somebody's observed the actual accident happen and described what happened. It's direct evidence. It doesn't need an inference or anything else for it to come on as evidence to prove who was responsible for the accident. So if whatever's in the statement cannot by itself prove whatever you're trying to prove, then it is not possible that it can be offered to prove the truth of the matter asserted for hearsay purposes. Hope that makes it a little bit clearer. All right, let's look at some other things. You must always know that the statement is offered you must always know what the statement is offered for at trial in order to determine whether the statement is hearsay. That means if someone said, well, I have the following statement, I want to introduce it, would it be hearsay? Unless you can tell from the context of what they're introducing why they want to introduce it, the answer is I can't tell you because I don't know why you're introducing it. So if you ever see a problem on any of the quizzes that simply says, here's a statement, is that hearsay? And nothing more, and you really can't tell from the statement itself what they're using it for, then no. Absolutely you cannot tell. You cannot tell unless you know what the purpose is. And if it's offered for a purpose other than to prove the truth of the matter asserted, it's not hearsay. And if you don't know, you can't say whether it's hearsay or not. So words that are offered to prove a state of mind also are not hearsay. So words where someone's very angry and they say, I'm going to kill you. Well, you're not bringing that on to prove that the person's really trying to kill the person. You're bringing it on to prove that they were angry. And that is a state of mind, and that's why it's not hearsay. It's actually not necessarily there to prove anything. People say all sorts of things that they never intend to do when they're angry, and so we don't bring it on for that purpose. Also, words that are inconsistent with the witness's current testimony are offered to impeach the witness and not necessarily for the truth of the matter asserted. Now, if we are trying to prove them for the truth of the matter asserted, we'll need an exception, and there is one. There's one both for federal and state. It just happens to be that the feds consider inconsistent witness testimony to be non-hearsay. The states consider it hearsay, but they have an exception for it. But either way, it comes in because it's all very good. We want to hear, if a witness comes on and testifies at trial, we want to hear that they said something different outside of trial. Most certainly we want to know. All right, things that are not hearsay because the law says so. This is only under the federal rules. It's Federal Rule 801D. Some things that are defined as non-hearsay, even if they may actually be hearsay. First is prior sworn inconsistent testimony of a witness. It could be that, let's say we had a preliminary hearing before the trial. At the preliminary hearing, the victim said something about the incident, and when they got to trial, they contradicted themselves and said something at least a little different. Well, then we want to impeach them. We want to use their inconsistent testimony that they had in previous preliminary hearing to show that they're not telling the truth here, because they have inconsistent statements. Normally speaking, that's an out-of-court statement being brought on to prove the truth of the matter asserted, but in federal people are just simply define that as non-hearsay. They just took care of the problem in essence of creating an exception by simply defining it out of hearsay. That's not hearsay. That's all they say, and it's really inconsistent with what the states do, so it's a little confusing. But again, what happens in the states is they define it as hearsay, and they have an exception for it. So there you go. All right, prior consistent statements of a witness used to rehabilitate them are also non-hearsay. Again, this would be considered hearsay in the state, but they have an exception for it. Okay, and the last is an admission of a party opponent intended to be used against the opponent. What admission by a party opponent is, when you have a plaintiff and a defendant, there's a rule, at least the state rule has an exception that says that if you're bringing on a statement by a party, and it's not a witness, but a party to the action, and one of the plaintiffs, one of the defendants, if you're bringing that on and you intend to use it against them in any way, then that's admissible over the hearsay rule. Federally, it's considered non-hearsay. State is considered hearsay, and we have an exception for it. Either way, these are three different categories of what the feds define as not hearsay, but the state defines as hearsay and has an exception for it. And so one is prior sworn testimony that we want to use, inconsistent prior sworn testimony, and then prior consistent statements of a witness used to rehabilitate them, and then an admission of a party opponent intended to be used against this opponent. And that means any statement we want to use against somebody. A lot of times we use statements against people for as long as I want to use it against them, and that's what I'm doing, then it'll come in as non-hearsay regardless, even though it's an out-of-court statement. And even though I'm trying to bring it in for the truth of the matter asserted, it's not going to be considered hearsay federally, but it's considered hearsay state, and there's an exception for it. All right, things that are not hearsay also include statements made by an opposing party's agent, or employee acting within the scope of their employment that is used against the opposing party. So it could be, for instance, you have a corporation that's one of the parties, let's say plaintiff or defendant, and one of the agents of them or one of their employees makes a statement that they purport to be for the corporation. Then that statement can be used against the corporation, even though it's not actually the corporation's statement. This is because they're acting in a representative capacity. And in fact, corporations can't speak, as we know, because they're just a legal figment of our imagination. But they can speak through people, and they can make admissions of things. They can make contracts with people through people, but they have to act through people in order for things to happen. All right, statements made by a co-conspirator during and in furtherance of that conspiracy is considered non-hearsay. What happens is very often we have wiretaps on conspirator cases, especially in drugs, for instance. And those be talking about exactly what they're going to do and how they're going to do it. They'll be making arrangements and so on. Those statements that are made during the conspiracy and in furtherance of the conspiracy are at federal, they're considered non-hearsay. State, they're considered hearsay, but we have an exception for them. Same thing. So these are several different categories that the feds have sort of just chiseled out of the definition of hearsay just by excluding them under Rule 801D, and it's just, again, a little confusing because the states don't do it that way. But I do want you to know that that this is the same thing. It's just, instead of making an exception for it, they made an exception by calling it non-hearsay. That's the same thing. They've done the same thing. All right, let's look at this flow diagram. What we have is a flow diagram that you have in your materials that I want you to look at. And I want you to follow this flow diagram anytime you're dealing with a hearsay issue. If you see a statement made out of court, it's being brought into a trial, you're automatically going to look to see first whether it's hearsay. If it is hearsay, then you're going to look for an exception to the hearsay rule. And just know that when we're doing our quiz, it's going to be the federal rules that you're going to be quizzed on, not the state. So you would have to define certain things that would ordinarily be hearsay as non-hearsay, because that's the way the feds do it. All right, now let me pick this thing up and let me show it to you. This is the flow diagram, and I'm going to see if I can't make that about the right size for you and make that fit nicely. If I can. It just takes a few seconds here. Okay, this flow diagram, I can't make it any smaller. Okay, sorry about that. All right, you should be able to see at least so far the part about the, is it a statement? Is the statement made outside of court? Is it being offered for the truth of the matter asserted? All right, here's this flow diagram. The first thing you do when you have a statement that is being made that you think, you wonder whether the hearsay rule might apply, is you ask, is it a statement? That's an oral or written assertion or nonverbal conduct of a person if it's intended by the person as an assertion to communicate. If no, then it's not hearsay because it's not a statement. You have to have a statement. If yes, then you go to the next thing. Is the statement made outside of court? Is the statement you're trying to bring in something was made outside of court by someone other than the declarant while testifying? If so, then yes, then you continue on. If no, you do not have hearsay because you don't have an out-of-court statement. Number 3, is the statement being offered for the truth of the matter asserted in the statement? Okay, if no, then you do not have hearsay because that's the second element that is required. So if the statement is not capable of proving some relevant truth without the use of an inference, then it does not meet this test. That's the first thing you need to know. The statement itself must be able to prove something by itself without having to have the aid of some other inference. So the initials J and L that happen to be on a piece of luggage needs the inference that people write their initials on things as ways of indicating ownership. And then the conclusion from that inference, the addition of that inference, is that that luggage is owned by me. Well, that would not be hearsay because you're really using it as circumstantial evidence of something else. All right, if the statement is being offered for a purpose other than proving the truth of the matter asserted, then it does not meet this test. So if you say to the judge, hey, judge, yeah, well, I guess I could have used it for the truth of the matter asserted, but I'm not trying to. I'm trying to use it for some other purpose. Then you get outside of the hearsay. So you ask this question: is the statement offered to prove something in the action solely by itself without the aid of an inference? If so, then you have hearsay. You have hearsay. And then we'll see in the flow diagram, we go down. The next question is the statement one of those that is considered non-hearsay because the law says so? Is it a prior and consistent statement? Is it an admission by a party, agent of the party, or co-conspirator of the party offered against the party in the case? Is the statement being used along with inferences to make it useful as evidence in the case? If yes, it's not hearsay. It's not excluded by the hearsay rule. That's just in the federal, because they defined away these things as being non-hearsay. And then, of course, you always bring in this next question: is the introduction of the statement more justly prejudicial than probative? That's the rule 403, that all evidence is filtered through. If yes, then you exclude it, but not because it's not admissible otherwise. All right, so the next thing is the statement is hearsay and will be excluded unless it meets one or more of the hearsay exceptions. And then we go through and look at the exceptions, which we're not going to get into for a little while. But right now, this is the flow diagram that you're going to be using for this week, and any time that you are looking for whether something is hearsay or not. Is it a statement? Is the statement made outside of court? Is the statement being offered for the truth of the matter asserted in the statement? Is the statement one of those that is considered non-hearsay because the law says so? And then, of course, the 403, which is always there to deal with. Okay, so I want you to use this flow diagram when you're answering any of the questions. I'm going to keep that up on your screen if you happen to have time, because I'm going to take it down for right now because we need to go back into our PowerPoint. But then I can bring it back anytime. So I'll probably just bring it back here in a few minutes. Now, you could practice by bringing up certain links that I have in the modules. The first link is a article called "Is It Hearsay?" and they brought in lots of examples. I'll go over a couple of those with you. And then the next one is Quizlet, which is another one that has this basically hearsay flashcards. Really good practice. This is very good practice. I want you to go through every one of these. It's that good. All right, so the first thing they do is, if it's looking for whether it is a statement or not, they bring in lots of good stuff about what it is that is a statement. So one over here is an out-of-court statement. We brought that. They bring that up as well. Offer for the truth, and so on. They actually do really good examples and so on for you to look at as well. I want you to go through this because I think it's worth your time to do that. And then they have a test. So you go to the test and you go to each one of these questions. Now, interestingly, they don't tell you what the purpose of the evidence is. I'm going to give you one, and then they ask you whether it's hearsay or not hearsay. The first one says, the testimony of a witness that she waved down a passing police car, pointed to a speeding blue car, and said, "That Mustang just hit a car and drove off." If offered by the prosecution, here it is, to prove that the driver of the fleeing car had hit the other car. Now that's where they did, in this case, they actually told you what it was being used for and what kind of case. Well, let's look at this. Statement by a witness that she waved down a passing police car, pointed to the speeding blue car and said, "That Mustang just hit a car and drove away." First of all, is it a statement? Almost certainly. When she waved down the police car, that doesn't really mean very much, except that she was just trying to get the attention of the police car. But she pointed to the speeding blue car. Now that's nonverbal conduct. It is intended to communicate. It's trying to direct the officer's attention to that particular car. And then we have verbal conduct, which is that Mustang just hit a car and drove off. So we have a statement. Is it an out-of-court statement? If it's testimony of a witness that she actually did these things, it's still out-of-court statement, because even if she's there to testify to what car hit what car, she's talking about her previous statement to the police officer. And so she's still talking about a statement that was made outside of court. So it is a statement. It is made outside of court. Next question, is it being brought on for the truth of the matter asserted? Yeah, because the prosecutor's there to prove that the driver of the fleeing car, the blue car, the speeding blue car, was the one that hit the other car. And so yes, the Mustang just hit a car and drove off. That's what she's trying to prove, that was that car who hit and ran the other car. And so yes, it is definitely being used to prove the truth of the matter asserted. So that's a good example, just to show you how important it is to go through all of these different tests. There's about I guess about 20 or so of these. I want you to go through each and every one of them and then indicate whether you think it's hearsay or not. But I want you to use this flow diagram in going through, but just decide which one it is, because that will get you trained on what the issues are that you have to answer. Just don't make a snap decision. When you make snap decisions, they're almost always wrong. And the reason why is because you haven't asked the right questions and you haven't answered the right questions in order to know whether in fact it's hearsay. You have to go through this test every time. Is it a statement? Is the statement made outside of court? Is the statement being offered for the truth of the matter asserted in the statement? Is the statement one of those considered non-hearsay because the law says so? Those are the questions you're going to ask and you're going to answer. Then you got to ask essentially 4 different questions to get to this idea of whether it's hearsay or not under the federal rules. Okay. All right. So when you go through all those examples, and when you can do all those examples correctly, and in both of the quizzes that are there in these 2 links you'll find in the module, when you can do that, you will be well versed in how to determine when we have hearsay and when we do not. Okay, so I want you to go through those things. I got to tell you, if you don't go through those, if you don't get to practice, and you will have nothing but problems with the hearsay rule from now on. And most of what we're going to be going over in the evidence right now is the hearsay rule and its exceptions for the next several weeks in class. In fact, most of them next to the rest of the class. So keep your flow diagram available. Go to each of these 2 links, do each and every one of the problems, and look specifically to see. Now, I want you to be warned. If you don't see anything in the scenario telling you exactly why the evidence is trying to be used, you should be able to figure it out typically from the context of what they're doing. If it's the prosecutor, you know why they're using it. They're trying to make some particular evidence against the defendant. If the defendant's using it, then they're trying to prove something that would get them off on the case. And so it's usually pretty easy to figure out why. So not all cases will they tell you why, but don't worry about that. You'll be able to find it out through just some good critical thinking. All right, very good. So that's what hearsay is. I want you again to go through all these things. If you don't, you will not do well on the next several weeks in class, and in the exceptions as well, because they all require the same amount of understanding what hearsay is in order to first find out whether you have hearsay, so you can now apply an exception to it. All right, so that's it for today. And if you have any questions, please feel free to give me a call.